will not get numbered again. Okay. So go ahead. You're on line. Go ahead, sir. You're on line.
Good evening to all of you. Yesterday I was just discussing the introduction to the Indian Contract Act of 1872. I also told you that it is a verbose enactment and it contained in itself the entire gamut of the commercial law or the mercantile usage or what goes on in the commercial world. So any person should have a thorough knowledge and information about the gamut of the Indian Contract Act. Indian Contract Act originally had a lot of sections and had within itself what is called the Sale of Goods Act, Specific Relief Act, Partnership Act, Railways Act, Negotiable Instruments Act, and the Indian Carriers Act. But what happened was the legislators felt that it's a verbose enactment and it has to be changed. And slowly what happened was the Contracts Act became an emaciated form and the various enactments like Sale of Goods Act, Specific Relief Act, Negotiable Instruments Act, Railways Act, Partnership Act, and Carriers Act was removed from the Contracts Act, and we have separate enactments for it. So today, as the Contracts Act stands, we have only two types of contracts. One is called General Principles of Contract from Section 1 to Section 75, and from, I think most of the sections are repealed, and from 124, we have got the Contract of Indemnity and Guarantee, that's called Specific Contract, and then bailment from 150 to 164 is bailment, and then we have the pledge and pawn also as far as bailment is concerned. Then we have the last chapter called the Law of Agency. Law of Agency is the lengthiest chapter as far as the Contracts Act is concerned. We will deal with it as and when we come to it. So first and foremost is, I think I discussed the definitions part of it also yesterday. So just close the door, sir. General Principles of Contract. Here, the first term that is defined is what is called an offer. What do you exactly mean by an offer? When one person signifies to another, please follow the sentence, please. Where one person signifies to another, his willingness to do, abstain from doing, forbear from doing, in order to obtain the assent of the other, is said to have made a proposal. Again, I repeat the definition, sir. Where a person signifies to another his willingness to do, abstain from doing, or forbear from doing anything in order to obtain the assent of the other is said to have made a proposal or is said to have made an offer. This is what all I discussed it also yesterday. But we did not discuss the types of offers which are prevalent. First one is express offer. In our mercantile world, in a commercial world, we have what is called lot of offers which we find in the newspaper, which we find in the television, which we find in the movies, which we find in the advertisement, or which we find in writing. They are called express offers. Express offers means anything in writing, anything in publication, anything through wide circulation. It is called an express offer. Second one is implied offer. Implied offer is sometimes what happens is a company distributes the profits to its employees by way of equity shares, and by implication every year this continues. This is called an implied offer, and it only applies to the employees of the company concerned. And third one is, it is said general offers. General offers means an offer which is made to the entire public at large, and any person from the public who comes forward and performs the terms of the offer is deemed to have accepted the offer and is entitled to the benefits of the contract. And fourth one is offers limited by time. A specified time is there. I think most of you are watching television, and mostly the Facebook, Instagram, as well as the YouTube channel. Offers open only till so and so. That means you have to subscribe Only you have to respond to that offer within that time frame concerned, and then once the time is gone, you cannot subscribe to it or cannot accept the offer. When it is limited by time, a specified time is mentioned, then it is said the offer is open till that time. Then next one is, and mostly you see there is a caption down also, TNC applies. That is terms and conditions apply. Then fourth one is naturally, sir, whenever festivals come like Ramzan, Bakrid, then your Deepavali, Dashera, Christmas, or Sankranti, offers are made by various companies. That is, the products are available to you at a discount. Our products are available to you at a competitive price. Or when you want to sell your car, the huge discount is given, and the price which is said to fetch will also be paid. That means it will be limited only for 10 days or 15 days. Until that time, you have to avail of that offer. Once that time expires, the offer comes to an end. That is where it is limited by time. For example, suppose let us say certain posts are advertised, that is for junior assistants or junior let us say junior assistants or junior clerks, senior clerks, superintendent, principal, lecturer, professor, reader, so on and so forth. Then the question is, you have the advertisement says you have to apply within a particular time and within a time frame, and also submit all your documents online. That is, you have to do it within that time. That is where it is limited by time, and time and tide does not wait for anyone. And within that time stipulation, you will have to accept the offer. That is called an offer limited by time. Then offers requiring regarding employment. Offers regarding employment. When the recruitment board advertises for certain posts, for example, the Railway Recruitment Board, UPSC, or the State Public Service Commission, so on and so forth, when vacancies arise, then suppose let us say you apply for junior judges post, then you will have to make an application within the time that is stipulated, and this is called that is, as far as employment is concerned, you will have to follow and adhere to the time schedule that is given. Then next one is offers according to a format. Then sometimes what happens is an offer is made in a particular format. You have to submit your intention to accept the offer, and then in that particular form, either you must give it by phone, give it online, or give it in person, give it in the inward section, or send it by what is called registered post, or send it by courier, or any other mode to the concerned office concerned. Only in that prescribed format, the offer has to be complied with. These are the different types of offers which are provided under the Indian Contracts Act. Then, sir, what constitutes offer? Offers. Here, abstinence. What do you mean by abstinence? Abstinence means when I'm supposed to do a particular thing, where I abstain from doing it, I promise to abstain from doing it, and subject to certain terms and conditions, then that is what is called where I do not enforce it. It is called abstinence, or keeping away from enforcing. Then next one is forbearance. For example, most of you know that once you are indebted to some other person through a promissory note or through a loan transaction, you address to the person concerned, sir, I am in a sir, I am in a very tight financial position, sir. I am not able to pay you immediately, but I promise you that I liquidate the entire debt within 6 months, and please don't take any legal action against me. That is what is called the banker forbears or abstains or keeps away from enforcing the claim which he has got against the debtor. That is what is called forbearance. Then third one is to do a positive or negative act. To do or do a positive or negative act. That means a negative act is I will not cut down the trees, I will not take possession of the property, I will not enforce the debt against you, or I will do a particular thing which will satisfy you. Then all these things constitutes what is called offers. Then we come to the next aspect, whether all of what are the types of offers which are enforceable. Invitation to offer. What do you mean by invitation to offer? Invitation to offer means where, let us say, property is sought to be sold, or in the leading case on that aspect is Harvey versus Facey. Harvey, Harvey versus Facey, Facey. Here in Harvey versus Fassy's case, what happened was Fassy, uh, Harvey brought an action against one Fassy, saying that he posed two questions. One is, Mr. Fassy, are you willing to sell your property? Yes, that's the first question. Second question is, I'm prepared to purchase it for £10,000. What are the two questions, sir? Are you willing to sell the property, your property? Number two, for the lowest price. Then what happened was, Fassi, he answered the first one, saying that he is willing to sell the property. But as far as the second aspect is concerned, whether he did not quote the lowest price at which the property is offered, then the question arises, sir, whether it's an offer and whether it's an acceptance. And this person, that is Mr. Harvey, by posing two questions, he has offered to purchase the property. Whether it has been accepted by Fassi, no, he says, Fassi says, first question is answered. He says, I'm willing to sell my property. But as far as the second aspect is concerned, he does not answer. What do you mean by does not answer? He does not quote the lowest price or expected price. Then in that case, an invitation to offer is not an offer at all. That is the case of Harvey versus Fassi. Then, sir, tenders. I think most of you know most of the government bodies, state government, central government, railways, then public sector units, and all these establishments. Now, periodically, they issue tender notices. They want certain works to be done. They want to see that certain works are carried out. Construction of a bridge, construction of a dam, construction of a project, so on and so forth. Then they advertise. They call for tenders, and tenders is any person from the public can respond to the tenders and also give his quotation whether he is willing to do it, and if so, at what price he quotes the price. Then along with you, different people are there who also submit their tenders. There is a time frame within which you must apply for tender. Then a day comes when the tender is opened in the presence of all the tenderers, and whoever quotes the lowest price, the tender is knocked down in favor of that successful bidder. So the question is, just because a tender has been advertised, just because a tender has appeared in the paper, just because certain works have been, there's an advertisement to complete certain works or commence certain works, it doesn't mean it is a concluded contract or it is an offer. It's only an invitation to offer, as subject to the tender being knocked down in your favor. So tender does not come within the definition of the word offer. It is only an invitation to offer. Are you able to understand, please? Third one is that quotations. So normally, when you're running an establishment, when you're running a college, when you're running an educational institution, you require books for your library, and you go to the shops, take the quotations from various shops. Whoever gives you the maximum discount and gives it at a price which you agree, then in that case you agree to purchase from him. So just asking for quotations, asking for the price, inquiring about the price, inquiring about the books available, what discount is going to be given, it is not an offer, because it's only an invitation to offer. That is, the choice is mine whether to purchase it or not to purchase it. When we bargain, when we arrive at that particular price, then only it becomes a concluded contract. But it is an offer, it is not an offer, and it's not an acceptance. Then, sir, the general offers. I think this also I discussed it yesterday, but I'll repeat for the benefit of some people who are not present yesterday. Here, general offers is a specific offer. I'll come to this. General offers will come later. Specific offer. What do you mean by specific offer? Specific offer means, suppose most of you are advocates. Every time in and time again, you find advertisements in the paper calling for applications for appointment of junior civil judges or district judges at the entry level. And normally the junior civil judges examination is a three-tier compartment. We have got the preliminary examination, that is the objective type. Then once you get to the preliminary examination, you appear for the essay type, that is the second stage. And even if you get through the second stage, you've got the third stage, that is what is called Viva OC, that is interview is held. And if you are successful there, then alone you are offered the post. So here, Suppose, let us say, an advertisement appears in the paper. Applications are invited for the purpose of recruitment of junior civil judges and reserved for scheduled castes and scheduled tribes and backward classes only. Suppose 20 posts are advertised, and out of 20 posts, let us say 10 posts are reserved for the scheduled caste and scheduled tribes, and 5 posts are reserved for the backward classes, 2 posts are reserved for women, and 3 posts are available at the open category. That means it is a specific offer, or let us say only for scheduled caste, scheduled tribes, and backward classes. That means only people belonging to that particular class, that particular community can respond or apply for the post. Any person from any other community than the classes specified is not eligible to apply for that post because it is reserved for a certain category of persons. This is what is called a specific offer. Then what do you mean by general offer? General offer means where the offer is made to the entire public at large and a reward also is promised, and any person from the public who comes forward and fulfills the terms of the offer is deemed to have accepted the offer, which results in an agreement, and subsequently it becomes a contract which is enforceable in a court of law. It is called a general offer. I will cite a case on that particular aspect also. That is the case of Carlisle, Carlisle, Carlisle versus Carbolic Carbolic Smoke Ball Company Limited. In this particular case, what happened was in UK there was an epidemic of influenza. Influenza is nothing but what we call it here as flu. And the Carbolic Smoke Ball Company said they have the skill and experience to to provide a cure for influenza. And it said, the advertisement said, any person who uses the smoke ball for a continuous period of 2 weeks, according to the printed instructions, and still afflicted or by influenza, the company shall pay a sum of £500 towards damages. The facts of the case are the Carbolic Smoke Ball Company made an advertisement, made an offer that it has got a cure for influenza, and any person who uses the Carbolic Smoke Ball for a period of 2 weeks, according to the printed instructions, and still affected with influenza, the company shall pay £500 as damages or reward for the breach. Then this Carlisle poor lady, she was affected with influenza. She, based on the advertisement, she purchased the Carbolic Smoke Ball and used it for 2 weeks according to the printed instructions, but she did not get cured of influenza. Then she brought an action against the company claiming the reward. She brought an action against the company claiming the reward based on the offer made by the company. Then the company contended, sir, the offer was not made to Carlisle personally, it was made to the entire general public, and since there was no privity of contract, we are not. Please, we are not bound to pay that reward. But the courts in this case held that an offer need not be made to a specified person. Samson, please. Go.
Please don't interrupt the class. Please mute yourself. I'm not available in the office. Please mute everyone. I request all the participants to mute yourself.
So as far as the company contended, sir, it is an offer not made to Carlisle. It was made to the entire general public. And since she was not a party to that specific offer, she is not entitled for the reward. But what the courts in this case said was they negated the argument put forth by the company by saying an offer need not be made to a person specifically. It can be made to the entire general public. Any person from the general public who comes forward and fulfills the terms of the offer according to the printed instructions or the terms of the offer is deemed to have accepted the offer. So it was held that Carlisle was entitled to claim the reward of £500. So in other words, the sum and substance of this case is an offer need not be made to a specific person. It can be made to the entire general public. Any person from the public who comes forward and fulfills the terms and conditions of the offer can avail the reward which is announced. That is the case of Carlisle versus Carbolic smoke ball company case. Then we go to, sir, the what is called acceptance. Before going into acceptance, we must know a quotation. An acceptance is an offer. Again, I repeat, an acceptance is an offer. What a lighted match is to a train of gunpowder. An acceptance is to an offer. What a lighted match is to a train of gunpowder. What do you mean by gunpowder, sir? Gunpowder, which is used in blasting rocks, blasting stones, so on and so forth. And it's a very dangerous substance and inflammable substance also. Suppose you find a tray of gunpowder on your table, and so long as the gunpowder remains unlit, it is a gunpowder in the original shape. But once the matchstick is lit and there's a big explosion and not a single particle of gunpowder is available and it is reduced to ashes, then it is said the question is acceptance is like that. Acceptance is to an offer what a lighted match is to a train of gunpowder. Once the proposal is made and an offer is made by the offerer and it is accepted by the acceptor in the terms and according to the terms and conditions in the letter as well as in the spirit, the question is the acceptor under no circumstances can take back his acceptance and say, sir, I want to back out. Please remember, once acceptance is made, it results in an agreement. That agreement, which is enforceable in a court of law, is what is called an agreement. And that agreement, enforceable in court, is called a contract. And once acceptance is made, nothing remains in the hands of the acceptor to revoke, to retract, or to go back as or resile from the acceptance which he has made. Suppose, let us say, sir, the acceptance you post it in the post box, you send it by post, or you hand it over to the courier. Then the courier takes it for transmission to the offerer. You cannot take it back. No person will give you that. But before the acceptance reaches the offerer, suppose, let us say, by the quickest mode of service, you take back your acceptance by wire or whatever it is, then it is said the acceptance is revoked and there is no agreement. And once there is no agreement, that agreement does not fructify itself into a concluded contract and it is not enforceable. Except in exceptional circumstances, once an acceptance is made, once it is sent by the mode which is prescribed, you cannot take it back except before the acceptance reaches the offerer, you take it back, resile from it by the quickest modes possible. Then in that case, the acceptance stands revoked. Only in those circumstances, an acceptance can be revoked. Then, sir, we go to the next aspect called the capacity to contract. Capacity to contract. That is, to enter into a contract or a contract to be valid and enforceable, there are certain qualifications prescribed. One is Section 11 of the Contracts Act says that any contract with a minor, a person of unsound mind, an idiot, or anyone who is disqualified under any law for the time being enforced, such a contract is void ab initio. That means it is unenforceable right from the beginning. Then we go one by one, sir. Who is a minor? Minor is defined under the Indian Majorities Act, that is a person who has attained the age of, a person who is below the age of 18 years. He is supposed to be a minor. In England, he is called an infant. But as far as India is concerned, he is called the what is called a minor. Sir, please excuse me, sir. As far as a minor is concerned, a minor is a person who is below the age of 18 years. That is, any contract with a minor is void ab initio. It is not enforceable at all. He is incompetent to enter into a contract. And so a contract cannot be made with a minor. That is what Section 11 says. Second one is unsound mind, or what he called it as a lunatic. A person who is a mad person. A person who has lost his senses, mental senses. A person who is not able to discriminate what is good and what is bad, is incapable of managing himself, is incapable of dealing with any other person. Such a person is supposed to be an unsound person, or what in Hindi it's called divana, or in Telugu it's called picho. Then we go to an unsound mind person. Please remember, as far as a person of unsound mind is concerned, under Section 11 of the Contracts Act, he is incompetent to enter into a contract, or any contract cannot be made with him. Third one is idiot. What do you mean by an idiot? Idiot in Telugu, they call it as what is called errodu. Errodu means a person who is incapable of discriminating between what is good, what is bad. He cannot take his own decisions. No decisions are binding on him. He doesn't listen to anyone. He doesn't know what he is doing, what he should do, what he should not do, or he does not have the repercussions of what he is doing. Such a person is called an idiot. And in Hindi, it's called the Aula Pasha. Then next one is persons disqualified by any law for the time being in force. For example, suppose a person has applied for insolvency. He wants to be declared as an insolvent. He has become diwala. He does not have money to pay all his creditors. Or let us say he gets an order that he is an insolvent, undischarged insolvent. Such a person, though physically he may be present, but legally he is supposed to be dead. No contract can be made with a person who has suffered a disqualification under any law for the time being in force. So these are the four people who are supposed to be darlings of equity, and their interests are zealously guarded by courts, and under no circumstances their interests will be jeopardized by an action of the court. Here, sometimes what happens is, nowadays I'm not talking about the minors of today. Minors of today might look much elder, much older mentally and physically compared to their father also, because thanks to being exposed to the media, thanks to being exposed to the what is called internet, so on and so forth, they know much more than what their parents know. Please remember, the IQ of a present day child is much more than what their father or mother has. That is a gift of today. And we really feel jealous of the present generation, because when we were studying, or when we were in college, or when we were in school, we were not exposed to the media. We were not exposed to the internet. We were not exposed to the cell phone. We are not exposed to the various aspects which are now played on the internet, or played on what is called the TV, so on and so forth. Today, the laws, please remember, no doubt the IT has come. But IT is good in certain respects, and it's also bad in certain respects. What the child should not know, for example, sexual education, they say. Sexual education, sometimes in the name of pornography, what is happening, child abuses also take place. And especially, I still remember in Twitter and all, the scenes which are put up is very, very disgusting. The child's morals get affected. The child who is a good child becomes immoral. So on and so forth. Good things are there, bad things are also there. But when we were there, when we were studying, we were not exposed to so many things. Today we have got various books, we have got various technologies, we have got various, and now I think the latest one is what is called artificial intelligence. That is now recently, if you open the paper, you find artificial intelligence, or AI as they call it, is prevalent in almost every sphere of activity, where the human, even though the intelligence may not be there, but still it is supplied through the internet, and how things are done, how matters are done, how machines are operated, how industries are operated. The tidbits are given to you on the television itself, especially on the internet. Here, as far as a minor is concerned, minor is supposed to be a doli incapax. Doli incapax, DOLI space incapax, INCAPAX. DOLI space incapax, INCAPAX. That means incapable of having a mental perception of things, what he is doing or what he should not do. And here, mostly in one of the cases, it is said a minor, a famous case of Mohiri Bibi versus Dharamdas Ghosh, which was the Indian case on that aspect, where it is said Dharamdas Ghosh versus Mohiri Bibi. In this particular case, what happened was a minor, misrepresenting his age, obtained a loan from a particular moneylender, and he created an interest in respect of his immobile property and executed a mortgage deed in favor of one X. Subsequently, X died, and his executors brought an action against Mr. Dharamdas Ghosh, claiming inter alia that the minor, misrepresenting his age, has obtained a benefit, obtained a loan, created a mortgage, and we wanted to enforce the mortgage to recover the debt. The court in this particular case categorically held that a minor's contract is void ab initio. Since a minor cannot enter into a contract, or no contract can be entered into with a minor, even if he has obtained a loan misrepresenting his age, that he is a full age, that cannot be enforced. So, in this particular case, the executors of the creditor could not recover anything from Dharamdas Ghosh. That is, in other words, it is a dicta of the Indian courts which said a contract with a minor is void ab initio. It's a nullity. It's null and void. It cannot be enforced at all. Even if the minor misrepresents his age and obtains a benefit, that benefit cannot be restored back to the other side. But please remember, England is a country which is a commercial country which was almost ruling two-thirds of the world at one time. There, the leading case on that aspect is a case of Leslie, L-E-S-L-I-E, L-E-S-L-I-E, L-E-S-L-I-E versus Shield, S-H-I-E-L-L, S-H-I-E-L-L. In this case, what happened was a minor, that is Shield, misrepresented his age and told the creditor he is a full age and he obtained a loan from Mr. Leslie. A minor, or in England they are called infant, misrepresenting his age, that is a full age, entered into a loan transaction whereby he borrowed some money from Mr. Leslie. Then Leslie, believing that the minor was a full age, advanced the loan. Then when the question of repayment came, the minor pleaded what is called minority and said that a contract with a minor is a nullity and it is unenforceable and it is null and void, not only from the beginning, right from the inception, it is null and void. Then the Mr. Leslie contended, sir, this person has committed a breach of contract whereby he has misrepresented his age. Please remember, a misrepresentation is both a tort means civil wrong as well as a breach of contract. And he obtained a benefit, and once he has taken that money, he has to return back that money. And he also contended, saying, sir, if the minor is not responsible in contract, make him responsible. As far as torts are concerned, he has committed a civil wrong by misrepresenting his age and obtaining a benefit through misrepresentation or representing false facts. In this case, the court refused to decree the claim made by Leslie by saying a minor's contract or an infant's contract is void ab initio. Right from the beginning, it's a nullity. You cannot enforce it. And if you want to make the minor responsible, a minor is not responsible in contract. But when a minor is not responsible in contract, you cannot make him liable or responsible in torts where he has committed a tort or a civil wrong by misrepresenting his age and obtaining a benefit. But the court in the rider said, if the funds are still available with the minor, if the funds are still available with the infant has to restore back that benefit which he has had, because the principle of unjust enrichment says you cannot take the cake and eat it too. If you want to avoid it on the basis of your minority, if any money is still available to you, that money can be recovered by the creditor. So, in other words, a minor is not responsible in contracts as well as under torts. This was the classic judgment rendered in Leslie versus Shield. Then, sir, there are certain exceptions also which are recognized as far as minor's contract is concerned. If please remember, every one of us, every living being, have to keep our body and soul together. There is a saying, they say, whether you live to eat or eat to live. The question is, even to eat, you must live, isn't it? And even to live, you require some money. So a minor requires certain basic necessities in life. For example, we are all civilized people. We come from a advanced stage, advanced life. Then please remember, you cannot go without a clothing on the road. You cannot go nude. You cannot undress yourself and display yourself in your birthday dress. Or let us say you require certain quota of dresses in order to make an appearance, or you want to present yourself in a proper shape. For that, you require certain necessities. You require suitings, or you require shirts, you require shorts, or you require pants, or you require shoes, or you require the various wearing apparel. They are all called necessities of life. As far as contracts of necessaries are concerned, it is a first exception to the rule that a minor's contract is void ab initio. What are contracts of necessities? Here, it depends on the social status of a minor. It depends on the financial position of a minor. It depends on his family background and from what background he comes. And there are what is good for you. You are an aristocrat. For you, you live a luxurious life. You always come out only in safari dress, or you come with white shoes and so or a Maruti car or so on. But as far as a person of a lower status is concerned, Maruti car, where safari suit, everything is a luxury. So the question is, he doesn't require it in life, but he requires certain basic necessities like roti, kapda, or makan. That is food, shelter, a place to stay, and makan. Makan is a place to stay. That is makan. Food, that is roti means food. Kapda, kapda is the dress, and makan, that is a place to where to stay. So these are the basic necessities of an individual, be it from the poorer section or be it an aristocrat. So depending on the social and financial background of an individual, there are certain things called necessaries. The leading case on that aspect, in English case on that aspect, is called the Clothier's case, Clothier's apostrophe S, Clothier's case, or it is also called the Taylor's case. The leading case on that aspect is Nash, NASH versus Inman, INMANN. Nash versus Inman. I think by the nomenclature itself, that's not an Indian case. It's a case which was decided by the English courts. In this particular case, nowadays most of the tailors are also running clothiers shop also. The cloth also is available with them. I think most of you are from Hyderabad. No, there's a very big shop in Badi Chowdi called B.N. Das. You get your black coat, he himself stitches it. You get your black gown, you get your bands and other wearing apparel which is required for an advocate. And here, as far as Inman was concerned, Inman was a minor infant, and Nash was a clothier who also undertakes stitching of clothes also. Then he took an order from the miner for stitching 11 suits and so on and so forth. Then the miner already had enough suits in the wardrobe and he did not require it. Then, in spite of that, the tailor, what he did was he used the cloth and stitched 11 suits as far as the miner is concerned. Then, when the question of payment came, the miner said, "Sir, I am a miner. I cannot pay you the money because a miner's contract is void ab initio." But the tailor contended, "Sir, even a minor, though the contract is void ab initio, a minor also requires certain basic necessities in order to sustain himself in life. He requires roti, kapda, or makan, and he requires the kapda." But the minor successfully contended, "Sir, already I have got 11 suits in my cupboard or in my wardrobe. I do not require these 11 suits, which are superfluous for me. I cannot afford for it. I am not prepared to pay." Then, in this case, the court was asked to decide whether it's a contract of necessaries and the minor can be made liable in spite of the protection given to the minor. In this case, the court said, as far as necessaries are concerned, you cannot put it into a watertight compartment and say these are necessaries and these are not necessaries. It depends upon the social status, financial status, requirement of the minor, affordability of the minor, and the question is whether the thing contracted for is required for his day-to-day life. For example, a beggar is satisfied with a banyan and with a short. You cannot tell the beggar, please wear a suit, wear a shoes, then have a clean dress and so on and so. For him, it's a luxury. Luxurious things cannot be offered to a person who does not have the wherewithal or the financial background. But as far as you and I are concerned, when we are advocates, at least we have to be presentable. We require certain things which are required. Then, in that particular case, only those things which are required for a minor, only those things which are necessary or which he can afford according to his financial background, they are only necessaries. And since the minor had enough stock in his wardrobe, he did not require it. The claim of the clothier to recover the money from the minor was negated. That was the case of Nash versus Inman. Are you able to follow this? Then the second case which was reported is beneficial contracts. Second exception is beneficial contracts. For example, please remember, I think we are all unfortunate. We come from a background where our family, especially the parents, are conservative in nature. Those days, I still remember, though my father was a leading advocate, he used to say, by 7 o'clock, you must be at home. Irrespective of whether you go to play or you go to dance, come back at 7 o'clock, and 7 o'clock, you must sit with your books. And those days we were fortunate. We were not exposed to the media. We were not exposed to the television. The only permission that was given to us was on Wednesday, that is from 8 to 9, to watch Binaka Geet Mala. And after 9 o'clock, the radio used to be switched off. But as far as the oldies are concerned in the house, they used to watch only the news. So those days we were brought up in a very conservative way. But here nowadays, if you see, I was stunned watching the YouTube. The I think one boy from Kochi, that is from Kerala, he only aged 7 years, Anirbhav or Anirbhav. That boy, he's a giant, he's a legend, he's a legend reborn. That boy was able to sing the songs of Kishore Kumar, Mohammad Rafi, Talat Mahmood, and other great singers like Kumar Sanu, Abhijit, and all these people. And what tone that boy has. And his pronunciation was absolutely up to the point. And I mean, hats off. And he is a Saraswati Putra born to his parents, and he must be having a premonition of his earlier birth. And now, and especially in Kerala, there's one more girl. I think I used to listen to her. That is Surya Gayatri. She started singing from the age of 3 years, and she was trained by the Guru Parampara, that is by Kuldeep. And her pronunciation was so good, and she was tipped to be the next MS Subbulakshmi reborn. So now the children, their IQ is very, very high. The parents also train them up properly. They give them proper encouragement. And please, as far as Surya Gayatri is concerned, I was told their parents stopped her from school and said she will have schooling from home. And she was practicing the kirtanas and all these things. And then we have the Sachin Tendulkar. As far as cricket is concerned, Sachin Tendulkar burst on the Indian screen at the age of 15 and 16. He was the youngest cricketer in the world who had his debut at the age of 15 or 16 years, and he didn't even play a single Ranji Trophy match, but still was selected for the Indian team. And now you have the what is called talent schools also in NCA, National Cricket Academy in Bengaluru, or you have various academies which are training up small children right from their childhood, and they are brought up in such a way that tomorrow they are going to be legends. What I'm trying to tell you is that, and these people, the talent is nurtured, talent is identified, and they're trained right from the rudimentary fundamentals, and they become great people. They may not have education, but still in sports they excel. Today, I think most of you have seen Paralympic sports in Paris. Most of the people who are handicapped, they have lost their legs, they have lost their hands, but still they have won medals in the Paralympics. That is, they have won gold medals, silver medals, and bronze medals for the country. Is it not creditable, sir? They are nurtured from the villages, and they come from a rustic background. Gone are those days when cricketers or sportsmen used to come from urban areas. Today, most of the sportsmen who are there, who are winning medals for the country, are from the rural background. They are nurtured right from the beginning, from a tender age. So these are the benefits which the present day generation has got. So what I am trying to tell you all these things is, especially when you try to join the Indian team, you are asked to write a bond. That is, you are under a contract with the board. That is, you shall not participate or you shall not take part in any games or any tournament without the permission of the BCCI or the cricket body or the hockey federation or so on and so forth. Even a minor also, the bond is taken from the minor. Why? Because the amount of training, the amount of coaching which is given, you don't want the child to go outside or go astray, and you want to nurture the talent and bring him up to win laurels for the country. What I'm trying to tell you is they are all supposed to be beneficial contracts. And a contract which is to the benefit of a minor, advancement of a minor, and his future life is secured by these beneficial contracts. The leading case on that aspect is a case of Roberts versus Gray, Gray, Roberts versus Gray, Gray. That in that particular case, the facts of this case are Gray was a world billiards champion and he entered into a contract with a minor, that is Roberts, Gray, who wanted to make billiards. He wanted to turn a professional and he wanted to become a world champion and he wanted to undergo training with a world champion like Roberts. Then, in that particular case, what happened was there was a contract between Roberts and Gray that Gray, after training, undertook to play 11 competitive matches in Canada in partnership with his mentor, that is Roberts. Then this minor, Guruను మించిన శిష్యులు అంటారు చూడండి. This minor exceeded his mentor and he became a champion to reckon with. Then at that time he turned ungrateful and then he said, Mr. Roberts, I don't want to play any exhibition games with you and I have nothing to do with you. Then what happened was Roberts brought an action against Gray claiming damages, saying that Gray has committed a breach of contract and the contract which was entered into with Mr. Gray was for the benefit of the minor who wanted to make billiards his profession, and I gave him the full training and full coaching, and I made him a potential to be a world champion. And he has committed a breach of contract. And since that contract was beneficial to the interests of the infant who wanted to make billiards a profession, and he has committed a breach, he should be made liable. In this case, the court held it in favor of Roberts by saying getting training and coaching from a person of the caliber of Roberts itself was a great thing for the minor. It was a benefit for the minor who wanted to make billiards his profession or who wanted to become a professional billiard champion. Then, and since he agreed and undertook to play exhibition matches at Canada, he has committed a breach of contract, and since it's a beneficial contract accruing to the benefit of the minor, it can be enforced, and Gray was asked to pay compensation or damages for the breach which he has committed. Are you able to understand, please? This is the second case as far as exceptions to the minor's contract is concerned. Then we go to the third aspect. Third aspect is consideration. What do you mean by consideration? Consideration is defined in section 2D of the Contracts Act as a recompense for the promise that is made. That is, recompense means, please remember, no one will suppose, let us say, A agrees to sell a particular property to B on the condition that B pays 50 lakhs as a sale consideration. That amount of 50 lakhs which you are going to pay, B is going to pay, is for exchange of the proprietary and the titular rights as far as the property of A is concerned, and that money which he pays to the offerer, that is the seller, is supposed to be the consideration. Consideration is defined as where it's a recompense for the honoring the promise which is made. Here, the question is, it may be in terms of money, it may be in terms of, it may be in cash, it may be in kind, it may be in any other thing. For example, suppose you buy goods from Bengaluru, then you place orders for supply of goods. Please remember, no fellow is a fool on earth to give you the goods at free of cost. Then what happens is the person in Bengaluru agrees to supply the goods to you on the consideration that you pay for it as and when it is delivered to you. So the question is, that man agreeing to sell the goods and you agreeing to purchase it and you agreeing to pay for it is supposed to be the consideration. That is a recompense. What you give in return for the promise made by the other side is called, for honoring a promise, what you pay, what you give in cash or kind is called consideration. For example, nowadays you have got online delivery, Amazon, Flipkart, so on and so forth. There you order for certain goods, or you order for, let us say, that you order for what is called knee guard, or you order for arm guard, or you order for helmet, or you order for something else. Then the question is, you need not pay cash immediately, sir. Pay cash on delivery. That means, as and when the Amazon person comes to you with the goods along with the price, you have to pay the price and then take delivery. He will not give delivery to you till such time you pay for it. Are you able to understand, please? Sometimes you may say, sir, prepaid. When you prepaid, you need not pay for it. For example, suppose in our day-to-day household, we try to, what is called, try to place an order for a refill cylinder. You have got two ways of paying it, sir. One is you on the cell number which is given to you, you place an order, and then you can pay the money, entire money, whatever is the cylinder cost, and then or agree to pay it when the cylinder is delivered to you. Please remember, no cylinder will be delivered to you unless you pay the price. Unless you pay the price for the refill cylinder, or either by prepaid or by post or on delivery. So the question is, what you pay for acquiring goods, what you pay for getting the goods, or what you pay for getting the goods on delivery. The question, the price which you pay or the money which you pay is called consideration. Suppose you go to a doctor, a surgeon, you want an hernia operation to be performed, or you want a particular appendicitis operation to be performed. You tell the doctor, sir, please perform an operation and I pay for it, whatever the medical charges are. Or I try to pay it through the insurance policy, which I've got as far as my operation is concerned. Here, sir, what are the terms, sir? As far as the surgeon is concerned, he agrees to perform the operation. As far as you are concerned, you agree to pay the you agree to pay the what is called pay the charges which are leviable. You don't mind about it. Now, once you get admitted in the hospital, they say Janu kidare was the Janu hospital. Even God forbid I should not go to an hospital. Why? Because first and foremost is whether you're dead or alive, they say first deposit 5,000 rupees. Please remember, sometimes in the midnight or something you have a heart attack. Please remember how to find 5,000 and 10,000, sir. You don't have good Samaritans around. You cannot ask your neighbor, sir, please give me 5,000 rupees or 10,000 rupees to get myself admitted in the hospital. I shall try to send you back tomorrow morning. No person will give you the money. So the question is, now money is collected in the beginning itself. The question is at least 5,000 or 10,000 you have to deposit in order to get yourself, even first aid to be done, you have to deposit the money. Then again, your other scams start like scanning only to go to a particular diagnostics, then getting a report, then getting your urine tested, get your blood tested, then get all and sundry done. The question is, these are what is called, what you agree to pay for the services rendered is supposed to be the consideration. So consideration is what money you pay to avail certain services is called consideration. Suppose you say all of you are advocates. When a client comes to you with a problem, you analyze the problem and then try to decide as to how the problem has to be sorted out. Please remember, you are not running a social service club. You use your brain and you use your skill, you use your experience, and for the brain which you are using, the skill which you are using, the experience which you are using to come to the rescue of a party, then the client agrees to pay you the fees. That remuneration which is paid to you for the services rendered by you is called consideration. And what is the consideration for the client? The consideration for the client is you rendering professional services. That is called the consideration. So consideration, any contract without a consideration is supposed to be a nudum pactum or a nullity, or it's unenforceable as far as foods are concerned. Are you able to understand this? This is what section 2 clause D postulates. Then there is one thing called, even as far as England is concerned, the question arises whether past consideration is a good consideration or not. Past consideration means a doctor has treated you, doctor has performed the operation as far as you are concerned, doctor has treated you in a proper way, your operation has been successful, you promise to compensate the doctor for the services rendered by him. And the question is, Please remember, it is not done contemporaneously. Money is not paid immediately. Surgery is not done immediately. But for the surgery which the surgeon does, you agree to compensate him by paying him the charges. That is called past consideration. But as far as England is concerned, it is no consideration at all. But as far as India is concerned, the question is even past consideration is good consideration as per law. If this is not recognized, sir, what would happen is most of us will have to turn up as Charana advocate or Doana advocate. Why? Because when a client comes to you, sir, आप ऐसा वस्ताद नहीं है साहब, आप ही हमारा केस करना. You are the sovereign born on earth. You are my God. You are my Allah, or you are my Jesus Christ. Please remember, all this flattery will not do anything, because you have got a thing to feed yourself. It's called a stomach. For that you require money, or you require vitamin M. You don't want to use your brain in order to render services. So for that you have to be compensated. Please remember that fees which you get, the fees which is agreed to be paid, or the fees which the client promises to pay for the services rendered earlier is called consideration. Are you able to understand this? Here, as far as consideration is concerned, a contract without consideration is supposed to be a nullity, it's supposed to be a nudum pactum, and it is unenforceable under the law. Then we come to the next definition, sir, free consent. Free consent. Free consent means where the consent or the acceptance which is made by you, or the తెలుగులో ఏమంటారు, కన్సెంట్ అంటే ఇది ఒప్పుకోవడం, ఆర్ ది ఒప్పందం ఏదైతే మీరు చేస్తారో, ఆర్ దానికి ఒప్పుకోదానికి ది క్వశ్చన్ ఇస్ ఇట్ షుడ్ బి ఫ్రీ, ఇట్ షుడ్ బి ట్రాన్స్పరెంట్, ఇట్ షుడ్ నాట్ బి tainted with any illegality, or you should not be, a knife should not be put at your throat and said, अरे करता या नहीं करता, नहीं तो तेरे जान से मार दूंगा. Then let us say you execute a promissory note under coercion, under threat to your life and limbs, or threat to your life and limbs, and not only to yourself but also to your family members. Naturally, sir, anyone will try to get scared. At that moment, there's an inertia. As far as your brain is concerned, your brain refuses to work. Then in that case, you give willingness to do a particular thing which you would not have done under normal circumstances. Then it is said it is vitiated by free consent is not present. In all cases where free consent is not there, or the person has not accepted it in toto, and he has been put under threat or coercion or threat or duress, or he is locked in closed doors and made to sign certain papers, or made to execute certain documents which you would not have done under normal circumstances, it is said free consent is absent. Then here, as far as consent is concerned, there are two things here, sir. Consensus ad idem. Consensus, CONSENSUS. Consensus ad idem. That means meeting of minds, identity of the subject matter, identity of the person should both be there. Unless they are there, the question is there is no consensus ad idem and there is no free consent. And in case there is no free consent, the contract is voidable at the option of the party whose consent is so obtained. I'll deal with everything in detail, sir. Only the definition part of it I'm going. Then we are going to next one is legality of object, or lawfulness of an object. That is, the contract which is entered into should be for a lawful purpose, should be for a legal purpose. It should not for the purpose of carrying out an unlawful act or a forbidden act which is prohibited under the statute, and it is called legality of object. For example, suppose I want to let out my house to a person to run a brothel, or to run a prostitute's den, or to run a matka den, or run it for a casino, or run it for an illegal purpose or an unlawful purpose. Then in that particular case, it is said there is no legality of object and it's unenforceable, or the contract is voidable. These are the various what is called essential ingredients as far as a contract is concerned. So this finishes the definitions part of it. Also, to some extent, we have completed offer, acceptance, as far as capacity is concerned. But as far as free consent and other things are concerned, we will deal with it in the next class. Any questions, please? Sorry, today the lecture was delayed because of our professional commitments. We are very, very sorry. We regret for it. Any questions by way of interaction, please? You are free to ask. Yes. Yes.
Yes, anybody have any questions?
Anyhow, I'm not going to leave you also. In the end, when I finish Contracts Act, I will try to pose questions to you, and I shall also try to clear your doubts, because this particular Contracts Act is a verbose enactment. It is not possible for anyone to carry on with the subject unless you understand it properly. I don't mind it repeating it again and again so that it drills into your mind, and you should not have any lingering doubts in your mind, please. I think there are no questions, sir. Varalakshmi Garu, you can just close down the show.
Yes, sir.
Yeah.
Yes, anybody have any doubts? Please raise your hands, and you are free to ask any questions.
I hope everything is clear for them. Thank you. Thank you very much. We conclude the class for today.
Sir, section 2D.
Mm-hmm.
Yes, who is this? Section 2D.
Consideration.
Section 2D.
Yes. Section 2D says any recompense for the promise that is made is called consideration. I gave you examples also. Suppose
Section 2D
Sir, sorry, Section 2D consideration. I know, sir, the beneficial contract, sir. Please, sorry. Beneficial contract.
Pardon? Beneficial contracts is, suppose a service is rendered to a minor who wanted to, that service he wants to make it, use it in a professional way, and he wants to become a world champion, and he undergoes training under a champion of world reputation, and then the training which he has had, and he agrees to perform in exhibition matches. Whether he likes it or not, he has to perform it. If he does not do it, he commits a breach of contract, and that contract, irrespective of the doctrine of invalidity of a minor's contract, is enforceable. Are you able to follow, please? That is Roberts versus Grace case. That is the billiards case.
I had listened, sir. Sir, thank you, sir. Thank you. Good night, sir.
Good night.
Vasantharaw Garu, please go ahead with the question, sir.
Good evening, sir.
Good evening.
Sir, already discussed again I have doubt, sir.
Yes.
My client was purchased a vacant flat from the agreement holder.
Yes.
The agreement holder has the purchase price original owner. Now we have to file the case. My client has to file the case. Then I have to make the party the original owner and the agreement holder subsequently.
You must make both of them parties, because an agreement of sale does not confer title. The question is, you may be in possession of the property, or possession must have been delivered to you. But unless you get a pakka sale deed, because here in India we don't recognize equitable estates, we only recognize legal estates. The question is, you must have a pakka sale deed. Unless you take a sale deed, you do not have title, sir. At the most, you can protect yourself under Section 53A of the Transfer of Property Act to say that in part performance of the contract, you have been placed in possession of the property, you are ready and willing to perform your part of it by paying the balance of the sale consideration, and then only when you take the sale deed, you become the legal owner, not otherwise. It is safer to make both the vendor as well as your previous person, whomsoever it may be, as parties. That's the reason, sir. In vendee, in favor of the vendee is nominees, assignees, representatives, or etc. etc. That means even a nominee can bring an action, sir.
Sir, what happened is the court was written that the original owner is not party to the contract, and how is it?
That is on the basis of privity of contract. The question is, the person with whom you have made an agreement, the person with whom you have entered into the agreement of sale, that person should be made a party.
Of course, sir, the court has written my case, taking such objection.
The question is, the vendor is definitely liable, sir. Look into section Article 50. I mean, Section 10 of the Section 10 and 11 of the specific fact, which says who can sue. The person who can sue is a party to the contract, a privy to the contract. Third one is the question of representative of the party, transferee of the party, the executor of the party, and the question of trustee of the party, all these people, if you see section 11 of the specific fact, the position will be clear to you.
Sir, any case law, sir?
You just look into section 11 of the specific relief act, so you get a lot of cases on that.
Okay, thanks.
All right, thank you very much. We conclude the class for today. We'll see you tomorrow again. Thank you.